Hi, my name is Ryan Foltz. I'm an attorney at Beresford Booth. I've been practicing for 25 years. My practice primarily involves construction litigation. Today, I'm going to talk about Form 17 seller disclosures, which are documents that you typically see in a home purchase and sale transaction. And so let's get to the slides. I've seen a recent uptick in my practice in the number of disputes related to Form 17s. And so the issues usually are the failure to disclose defects with the property, or in this particular case, what I'm going to focus on relates to renovations and remodels with the property that may not have been disclosed. And there are a number of issues that arise. The Form 17 is a requirement by statute. It requires sellers to identify and disclose no conditions with the property. It's an informational document. The interesting thing is it's not part of the purchase and sale agreement, but it is a document that can give rise to claims if there are, for example, unpermitted renovations or if there's undisclosed defects in the property. Importantly for a buyer, you have 3 business days to rescind an offer to purchase property. So read the Form 17 closely and look at all of the different portions of it. It is structured in a way that it goes through different elements of the property, structure, utilities, other things like that. So pay particular attention to what's being disclosed. And if there are any issues or questions as a buyer, you're going to want to follow up. So both buyers and sellers do face risk with the disclosure document itself. The sellers face risk for failing to disclose. Buyers face risk if they fail to follow up on evidence or notice of potential problems with the property. So where to look? Page 3, look under structural. I've highlighted the portion that talks about whether there's been any conversions, additions, or remodeling. And so you'll see these boxes, yes, no, don't know. I've seen all different iterations of this. I've seen folks that have falsely stated whether there was a renovation or not. They hid it. They didn't tell you about it. I've seen folks that will identify that there has been a remodel, but then leave boxes blank as to whether there were permits or required inspections. And I've seen folks that have check boxes in a number of different ways saying, yes, there were permits. No, there were not inspections performed, or, some different iteration of yes, no, and I don't know. And the problem for the buyer is that if there is some evidence that there was a remodel performed, but there were no permits or there were no inspections performed, you could be purchasing a non-compliant property that can lead to headaches down the road. So as I discussed, sellers must disclose known material facts about the property, and that includes whether there's been a renovation or remodel to the property. Sellers are not liable for any errors and omissions for facts that they simply don't know, right? So if there's conditions with the property that they're unaware of, they're not going to face liability for that. But failing to disclose known defects, or in the worst case, concealing defects, taking steps to actively conceal defects or actively concealing renovations or remodels that were not properly permitted, that will lead to liability. As I said before, a buyer does have a duty to investigate. So if there's some evidence or some notice that the property went through a prior renovation, the buyer needs to take steps to investigate it. And that's information that's publicly available. You can go to the local building department. You can look up the property to see if there are permits that have been pulled, when those permits were issued, and if they have been issued, whether or not the proper final inspections were completed by the building authority. Importantly, with the Form 17, you're going to want to look at that section that talks about renovations and remodels. Look at the boxes. If there is any indication that there was a renovation performed, make sure that the permits were pulled and make sure that the proper building inspections were completed. If you don't do that, you run the risk of potentially barring a claim down the road for failing to diligently inspect the property. If you buy a non-compliant property, it comes with risks. The local building authorities will, in most cases, if they identify and discover that there's non-compliant work on a property, they will enforce compliance, and that can lead to costly repairs. Worst case scenario would be usually if there's been structural modifications, for example, taking down a wall, opening up a room to make it a more kind of open, modern feel. If there were no permits issued and no structural inspections performed or engineering, the local building department is going to make you open up the wall to see how it was framed and to make sure that it's actually structurally sound and safe. If the property remains non-compliant, the city can also issue fines, or in the worst case scenario, they can start a civil action for properties that remain non-compliant and have accrued fines over time. And the amount of those fines can escalate pretty quickly. So the takeaways for buyers and sellers ensure accurate and complete disclosures in your Form 17. If you know of defects, if you have concerns about the condition of the property based on living in the property, a leaky roof or whatever, disclosing more is going to be better for you. Failing to do that can expose you to the potential for failing to identify or disclose a material fact to the buyer, especially for renovations and remodels. If you have renovated the property, you're going to want to disclose it. You can identify that the renovation was performed, permits and inspections. Be honest. Identify what was done and let the buyer's due diligence to follow through and determine what the compliance issues may or may not be with the property. For the buyers, really conduct a thorough review of the Form 17 disclosure. Those are the facts based on what the current occupant of the property knows in terms of the condition of the property. If there is any evidence of non-compliance, whether it's with renovations, remodels, or if there's any indication that there might be potential defects with the property, you're going to want to follow up, have somebody look at it, and do further due diligence. Otherwise, you may be buying a property that presents some significant risk. For buyers, also understand that purchasing a non-compliant property, I understand the market can be very active and move quickly, and sometimes it feels like buying the property without inspecting it might be the best thing for you because you want to get the property. Well, if you do that, there are significant risks that come with it. The most significant would be having to pay for significant repairs of the property to make it compliant, or in the worst case scenario, paying fines or facing an enforcement action from the local building authority. If you have any questions about Form 17s or construction related questions, feel free to give me a call. We can set up a time for a consultation. Our firm also is a full service firm, and we have a number of attorneys in different practice groups, and we're always happy and willing to sit down and have a consultation and talk to you about your legal needs. Thank you.